Welcome to the Legal Masterminds podcast. This is where sharp minds meet sharp law. We break down landmark cases, teach strategy, and keep you steps ahead. Whether you are a lawyer, law student, legal intern, or just someone who loves smart conversations. Inside this podcast, we do not just talk law, we unlock it. Want to join the community behind this podcast? Send us a DM. We promise you will love it here. Now let us get into today's case.
This is a summary of Nicon Insurance Limited versus Brighthouse Estate Limited, a decision of the Supreme Court of Nigeria delivered on the 7th of February, 2025. Nicon Insurance and Brighthouse Estate had a commercial agreement. The agreement contained an arbitration clause. At some point, a dispute arose. They referred it to arbitration. The arbitrator ruled in favor of Brighthouse. Nicon was unhappy with the outcome. It went to the High Court to challenge the award. The main complaints were twofold. First, Nicon claimed that the necessary steps before arbitration had not been followed. So, the arbitrator lacked jurisdiction. Second, it argued that the arbitrator had gone beyond the scope of his powers. The High Court dismissed both objections. It found that the arbitrator had jurisdiction and said there was no misconduct. Nicon appealed to the Court of Appeal. But that court also upheld the award. Still not satisfied, Nicon brought an application to the Supreme Court. It asked for four things. 1. An extension of time to apply for leave to appeal. This was 19 months after the deadline. 2. Leave to appeal. The grounds involved mixed questions of law and fact. 3. An extension of time to file the appeal itself. 4. A stay of execution of the lower court's judgments. Why did Nicon say it was late? It blamed the Court of Appeal's crowded docket. Brighthouse opposed the application. It argued that Nicon had not shown exceptional circumstances. It also insisted that the award should be enforced, since both parties had agreed to arbitration from the start. So, what did the Supreme Court say? Justice Idris delivered the lead judgment. He began by explaining the legal framework. Under Section 27 of the Supreme Court Act, and Order 2 Rule 31 of the Supreme Court rules, an appeal against a final decision must be filed within 3 months. If it is an interlocutory ruling, then within 14 days. To get more time, you must show exceptional circumstances. And you must file an affidavit that includes a good reason for the delay, a copy of the judgment being appealed, and proposed grounds of appeal that show why the case should be heard. This discretion is not automatic. The court may grant the extension, or it may refuse it. So, did Nicon meet the conditions? No. The excuse of a busy court docket was not enough. The court found it unconvincing. Next, the court examined the proposed grounds of appeal. Nicon listed 6 grounds. All alleged errors of jurisdiction. But they were not tied to the record. The court described them as baseless, even fanciful. There was another issue. Both the High Court and the Court of Appeal had already decided the question of jurisdiction. That is what lawyers call concurrent findings. If you want the Supreme Court to disturb them, you must show perversity. Nicon failed to do so. The court then looked at the broader picture. Arbitration is a choice. It is meant to be final, fast, and efficient. If parties are allowed to pick apart the outcome with technical objections, the whole system breaks down. That, the court said, must not be allowed. As for the stay of execution, the court refused. There was no arguable appeal. So, there was no legal reason to delay enforcement. Brighthouse had asked the court to order Nicon to deposit the award sum, 1.9 billion naira plus interest, if the stay was denied. But since the entire application failed, that question did not arise. All 5 justices agreed. The application was dismissed.
Hope you enjoyed this case. Now imagine having access to minds that break down the law like this every single week. Why not join our Legal Masterminds community today? We do more than analyze cases. We build legal giants. One thing we promise you, you will stay up to date with Nigerian law, master powerful legal strategies, and connect with people who think just like you. Our next meeting is this coming Saturday at 8 p.m. West African time. We are always prompt. No delays. Send us a DM to join. The seat is yours if you are ready. Till next time, stay learning, stay bold, stay sharp.